Ghislaine Maxwell has unexpectedly filed a more than 50-page habeas corpus petition in federal court, seeking to vacate, modify, or reduce her sentence. According to the filing, Maxwell claims that new evidence has emerged showing that her prosecution and trial violated the Constitution, suppressed evidence favorable to the defense, and presented misleading information to the jury. She asked the court to either overturn her conviction entirely, grant a new trial, or at least reduce her sentence. Notably, the petition was filed by Maxwell herself and does not bear a lawyer's signature. Even though she was previously represented by some of the top criminal defense attorneys in the country, the timing of the filing immediately raised questions. Is this a genuine legal effort, or a strategic move designed to create a shield for the Department of Justice to delay the release of the Epstein files? In reality, Maxwell has already appealed her conviction, lost at every level, and even had her case declined by the Supreme Court. From a legal standpoint, her conventional avenues are nearly exhausted. Meanwhile, Congress, particularly Democrats in the House of Representatives, is seeking to question Maxwell and pressure the DOJ to be more transparent about Epstein-related materials. Those documents are believed to involve not only Epstein and Maxwell, but may also contain the names of at least 10 other individuals who have never been charged. It is precisely in this context that the habeas corpus petition has emerged. The issue is not simply whether Maxwell has any chance of a reduced sentence. The real question is how this filing will be used in the political and legal tug-of-war surrounding the Epstein files. To understand that, it is necessary to look squarely at what Maxwell is asking for, the arguments she is making, and why most of them have already been rejected. From there, Maxwell expands her accusations to encompass the entire investigative and prosecutorial process. She alleges that civil attorneys representing victims worked closely with federal prosecutors, not merely to share information, but to drive the prosecution through public and media pressure. In Maxwell's telling, the criminal investigation did not arise solely from law enforcement obligations, but was steered by objectives outside the courtroom. All these do. This accusation quickly leads Maxwell back to a central issue that has haunted the case for years: the 2007 non-prosecution agreement between Jeffrey Epstein and the U.S. government. Maxwell again argues that she should have been granted immunity as Epstein's alleged co-conspirator. This argument has been litigated repeatedly and decisively rejected, including during the period when the DOJ was under the control of Donald Trump. What is notable, however, is that to sustain this claim, Maxwell is forced to acknowledge that she was part of Epstein's group of accomplices, an indirect but unmistakable admission that she herself included in the court filing. Maxwell goes further, asserting that the U.S. government deliberately delayed prosecution for decades, to the point that by the time the case went to trial, her ability to defend herself had been severely compromised. Under this theory, witnesses had died, memories had faded, documents had disappeared, and the delay could not be considered harmless. But this argument runs into an unavoidable reality. Throughout that entire period, Maxwell was never cut off from the legal system, never barred from access to attorneys, and never sought a court order compelling the government to act sooner. Her next accusation targets prosecutors directly, claiming that victim lists were destroyed or falsified. This is one of the most serious allegations in the entire habeas corpus petition, because if true, it would amount to the destruction of evidence. Yet Maxwell offers no concrete proof that such conduct actually occurred, relying instead on inferences drawn from civil lawsuits and indirect materials. After Epstein died in custody, Maxwell incorporates his death into her defense narrative. She argues that Epstein's absence deprived her of access to critical documents and information, including the history of negotiations with the government and records related to the network's operations. Under this framing, Epstein's death was not only a personal tragedy, but also a factor that rendered Maxwell's trial unfair. But when all of these arguments are placed side by side, a clear pattern emerges. Most of them are not new. They have appeared before, been litigated, and been rejected. Maxwell has appealed, lost, and petitioned the Supreme Court, which declined to hear the case. Legally, where her path has long been largely blocked. All of this leads Maxwell to a claim with a distinctly political tone. She argues that she was prosecuted only because Epstein was dead and the authorities needed a name to reassure the public. In this version of events, Maxwell is not the central figure in a criminal network that operated for years, but a substitute defendant for someone who could no longer stand trial. Her remaining arguments focus on an allegedly miscalculated sentence and pretrial detention conditions described as harsh and beyond permissible limits. For these reasons, the true value of this habeas corpus petition does not lie in its ability to overturn the conviction, but in its strategic effect. In sensitive cases, the mere existence of a pending proceeding can be enough to justify delaying the release of documents. Under the rationale of protecting the right to a fair trial, Maxwell and her lawyers have previously relied on this very argument to oppose the release of grand jury materials in New York. Now, the same card is being played at a moment when the DOJ is under pressure to release additional Epstein files. The fact that Maxwell is currently serving her sentence in a low-security federal prison only raises more questions. Her conditions of confinement, compared with many other federal inmates, are widely seen as relatively comfortable. She has time, access to legal materials, and the ability to draft a habeas corpus petition dozens of pages long on her own. This is not a trivial detail. It suggests that Maxwell is not isolated or completely desperate. On the contrary, she remains engaged in the process, on her own terms. From that perspective, the habeas corpus petition is no longer merely an attempt to escape punishment. It becomes a signal, a message that Maxwell remains present in the legal and political landscape surrounding Epstein. And as long as she remains present, the Epstein story cannot be fully closed. It is within this standoff that the most important question begins to surface. If the Epstein files truly revolve around nothing more than a deceased sex trafficker and a convicted accomplice, why has disclosure been so difficult? Why does every step forward require complex legal justifications? And why can actions like Maxwell's habeas corpus filing slow a process that has been awaited for years? The answer likely does not lie entirely in the courtroom. It lies at the intersection of law and politics, where information becomes power and silence becomes a form of currency. Maxwell understands this, and so do those who control the Epstein files. That very contradiction raises an even larger suspicion. Is the protection of the Epstein files truly about safeguarding victims and due process? Or is it about shielding other names that have never appeared before the public? Who are those names? And how are they connected to the centers of political and economic power in the US? In this picture, Maxwell becomes a uniquely positioned figure. She is both a convicted defendant and a holder of information that could seriously damage many others. And for that reason, Maxwell's silence, over time, acquires value, not moral value, but political value.